And this is actually Lemkin's tomb with the dissenting opinion. And if you can scroll up to show more of that picture.
Where's his tomb, Michael?
Don, where'd you go? Oh,
Cemetery.
in Queens, in New York.
Very simple grave marker.
Okay. Now, can we go back to the picture for this one? How do we do that? What do we push? Yeah, to the previous. Yeah. I think it's previous. Click. Tim, what do we need to push to get the thing back? Or date?
Ja, dit is mooi.
Well, Don, thank you for that. That's an interesting picture.
Je
How
weet
do we
het
get back
probleem,
to the
hè?
last slide?
Ja,
Het probleem, ja. Kijk, dus er wordt iets
Not
over
that one,
gezegd.
but the next one. There we go. Okay. We are going to now move right into our panel number 4, and I know we're all starting to wear out. I think I may have had eyes bigger than my stomach, hard to believe, in terms of scheduling all of these wonderful panels. But this is panel 4 of 5, Defending Individuals Accused of Genocide, and it's my pleasure to introduce Mark Ellis, the Executive Director of the International Bar Association, which is an organization with 30,000 members in 194 countries. Mark was formerly Executive Director of the American Bar Association's Central and Eastern Europe Law Initiative. He was legal advisor to the Kosovo Commission. He was one of the founders of the International Legal Assistance Consortium, and he's been an advisor to Defense Counsel in at least 3 international war crimes tribunals, and we're just really excited to have you back here, Mark, and moderating this panel. Thank you.
Michael, thank you very much. Nick, come in here. Yes, the defense counsel's late.
Yeah, did the prosecution say anything interesting?
There are not as many people here now because the defense is now coming on, so it's the same. It's the same story we have to deal with. For any, I think, for any court, for any case, I think we can say with some conviction that that it's exceedingly important to meet international standards of fairness. And I recall the first time I ever met Richard Goldstone as the chief prosecutor for the ICTY. After about 2 hours of meetings, I was there to see how we might be able to assist him. And in the end, he said, well, what I really think we need to do is to provide as much assistance on the first case that was before the ICTY, and that was the Tadic case. And it was that time that I had the real pleasure of meeting Professor Wladimiroff, who was the first defense counsel in front of the ICTY for the Duško Tadic case. And what we're going to do today is each panelist is going to speak for about 10 minutes in a particular area, and then we're going to open it up. So we're going to have about half of our allocated time opened up to the audience and to a number of questions that I might have in case there's silence from all of you, which I hope is not the case. We're delighted to have a really just a great panel, and I was very appreciative when they accepted my invitation to come here to do this after Michael had asked me to put this together. And I'm very appreciative to Michael for all the things he continues to do in this field. He's quite remarkable and a very close friend. Mischa Wladimiroff is one of the most prominent and preeminent criminal law attorneys in the Netherlands. He also has that same degree of recognition and level of expertise in the international community in international criminal law. As I said, undertook the first trial in front of the ICTY in defending Tadic. He's also defended cases in front of the ICTR, and his most recent case in front of the ICTY was as amicus curiae for Milosevic. So he comes to this table with a really significant background and knowledge in defending individuals accused of genocide. He's going to speak about some of the characteristics of the genocide cases from a defense perspective, and particularly as to some of the issues of specific intent, which the panel of the prosecutors talked about first. So I'm going to hand this over, Mischa, to you right now.
Thank you, Mark. I'm very privileged to be here, and I'm very grateful to have the opportunity to participate in this conference and to speak. For the record, today only 14 times a reference has been made to defense counsel. Isn't that very typical for the position in which defense counsel is? Reality is that in many criminal cases, the public does not consider defending individuals accused of having committed crimes, that is, criminals, as a noble profession. And when defending individuals accused of a genocide, the challenges are even worse. Those familiar with the criminal justice system, however, appreciate that we do not defend the act for which the accused person is prosecuted for, but we do defend the individual. And therefore we also defend the principles of a fair trial of the society of which he is a part of. So defending, after all, is not that onerous as people may say. And we could have been mentioned a little bit more than only 14 times today. Now, what are the challenges when defending a genocide case? Let me briefly list some, and then I will go into a few of them. We are dealing with international trials rather than national trials. So we deal with procedures we are not familiar with. We deal with different practices we are not familiar with. And the crime scene is always somewhere else, abroad, in a troubled area. Very difficult to access, and there's always a problem in approaching people and to find documents. I will come to that later. We also deal with high-profile trials. These are not trials around the block. These are trials with mass media attention. And therefore, defending an accused person in these type of trials, you have to deal with publicity. And that is another skill than defending an accused person. We also deal with a high political factor. This is not an ordinary manslaughter, for what reason it may have happened. Here there's always the political factor. And we deal with high-profile defendants. And on top of that, we deal with another language. At least some of us, at least me. But the language is also a problem for everyone. Because, for example, take the Rwanda tribunal. If you would ask a question to a witness in English, it will be translated from English into French, or from French into Kinyarwanda, the local language, or from Kinyarwanda back to French, or French to English, and then it hits your ear again. And you may experience that you've asked something and you hear it translating, and then you hear an answer in a language you don't understand. That will take about 1.5 minutes. And then the translation comes back, and the translation says, the witness says yes. And that's all you get. So you lose a lot on the language. We all lose on the language. Now take, for example, another challenge, which is, let's say, not really unique. It's the challenge defense lawyers always have to face. Let's take, for example, the principle of innocence. The legal theory is clear. All of us here in this room, we do understand what it means, and we try to live by it. But in reality, the practice is totally different. The presumption of innocence is, in most cases, given a kind of lip service that it sounds right, but in practice it doesn't work right. It has a large damaging effect on a trial when the publicity is not observing this principle either. The accused person is pictured everywhere as if he has done it, and in genocide cases it's even worse. So we have to take into account a few difficulties. One of them is the presumption of innocence is a legal concept, but not a concept for the public out there. And you will find in the courtroom that it reflects to the participants there as well, for the prosecutors and for some of the judges. Now, I may remind you, and I will come to that later, that we deal here with people who may be a crook in the courtroom. You see, I forget about the presumption of innocence as well. But at home, for some of these people, they are heroes. So we deal with the split personality issue. Are they heroes? At home, yes, they may be. Are they crooks? Yes, in the courtroom they are. And as a defense lawyer, you have to find your way through it. Now, defense counsel may be appalled by the public, because the question always is, why on earth would you defend such a monster, if I would emphasize the wording of David Crane? Why would you defend a monster? Because he should be prosecuted, tried, and perhaps even the phrase would be hang him first and try him later. Now, let's get serious. What are the specific challenges when defending individuals accused of genocide? For the purpose of the presentation, I have clustered two issues: the law and the person, the substantive law and the person of the accused. As far as substantive law is involved, the defense counsel are always keen to interpret the test to be applied. Of course, there are two ways. One is to narrow the test as much as you can, hoping that your client will not fall within the test, or the other one is to create some kind of room to maneuver. So you will argue that your client, on the face of it, may be in the test, but effectively he doesn't copy the test. Or as the lawyer of O.J. Simpson said, if it doesn't fit, acquit. So the paramount test in all genocide cases is always the test of special intent. We heard a lot of it this afternoon, and the issue may be this. The test has, as we all know, two components: knowledge and intent. As far as the component of knowledge is involved, there is little or nothing to do for us defense lawyers. It is quite a simple test. It's more or less driven by evidence and not by interpretation. Because theory is extremely clear on the issue. It's not only knowledge, but also awareness of circumstances that exist or consequences that may occur in the normal course of events. So again, for us it's more or less a matter of whether the evidence fits and not a matter of how to argue how the test will be applied, whether there will be room or it will have to be more narrow or not. And that is actually a matter for us that we should not really focus on if it comes to the law. It is a matter for us we have to focus on only in terms of evidence. Now, we all know that knowledge or awareness should be connected to what I could describe as a plan or a policy or a project. And that, of course, may a point of interest for a defense lawyer to focus on. But again, it is not a matter of interpretation of the law, it's more or less a matter of evidence. So I will leave it for what it is. The other component is more interesting. It's the component of intent. Not a normal intent as we are familiar with in ordinary cases, in the common crimes. That's the usual test of, has to be proven that the offender actually had the purpose to engage in the conduct or to cause the consequences, and we all know the escape route for the prosecutor by the theory of the dolus eventualis, because it also includes foreseeable consequences. No, we are dealing here with a more strict intent. The starting point for a special intent is the combination of the performance of the act and the purpose that goes beyond the mere performance of that act. So the test is, and we defense lawyers are always very keen on that, the test is, did the offender clearly seek to produce the act? That is, to destroy a specific group. Now, defense lawyers may have some room to maneuver if the debate will start about, but what does it actually encompass? Does special intent, let me phrase it in this way, is special intent a direct neighbor of general intent? In 2 minutes, I take the point. Well, defense lawyers will argue there's always some space in between. So there is some room to maneuver to argue that there is no simple borderline between a general intent and a special intent. Was the specific group destroyed because the perpetrator was reckless as to the consequences of his act? Defense lawyers realize that there is a very thin line between negligence and omission. Yes, an individual may intentionally omit to perform an act and thereby participating in the results, but defense lawyers will find that the line will be easy to overstep and argue, no, it's not a matter of omission, it is negligence, and therefore there won't be any special intent. The problem may be that omission may also be the result of negligence, in which case no genocide can be proven. Now, another issue in the debate will be the applicability of the test of special intent to others than the principal offender. Here again, defense lawyers are interested to find the specific limits. Does that apply to accomplices? And if so, what if the principal offender has no special intent? How does that work out? These kind of issues are issues that defense lawyers are always focusing on in these type of cases when they defend individuals accused of genocide. Now, I will abstain from going into the other aspect, that is the person of the accused, but I will make only 2 quick remarks to end up within the time allotted to me. The first one is, we are dealing here usually with very powerful people. And we deal with people who have strong opinions, and there's always the ethnical issue. Him belonging to one group and the victims belonging to the other group. Mostly an ethical issue, but it may also be of another type of a difference. Now, having that in mind, defense lawyers will have to face specific problems when dealing with these kind of people. Because the theory has it that you are instructed by the client, but the practice here is you have to accommodate with your client. You have to find common ground and to find a kind of compromise how to approach the case. On a number of issues, for example on strategy, on selection of witnesses or how to deal with witnesses, and most importantly, how to fit in the politics. Client will usually want you to put in every politic issue he has to say, and you as a defense lawyer know exactly what he shouldn't and what will ruin his case. So there again, you will have to find a common ground. Now, let me conclude by saying this. Defending an accused person, whether it is genocide or any other crime, actually comes down to one thing, and that is you have to perform your function as defense counsel in an objective way, in an independent way, but in a very partial way. And by doing so, you have to do it in a decent way. You have to be effective for your client, you have to do the best you can offer him, and in the same time you have to be loyal to the legal system in which you function. Because after all, people will understand you have done a decent job and an honorable job when you act along these lines. Thank you.
You should. Thank you. I mean, one of the issues I hope we get into at questions and answers, of course, Mischa was in a unique situation of being assigned by the court to look after the interest of Slobodan Milosevic, and yet Slobodan Milosevic, of course, had determined he did not want counsel. And so how do you go about looking at the interest of a client, not even your client, when defending genocide, and in the interest of the court to ensure that the defendant's rights are in fact protected? Stuart Alford is an English barrister, again a very prominent individual in the English bar. He was, in fact, a prosecutor at the Special Court for Serious Crimes in East Timor. He was also part of the UK delegation on the Rome Statute. And on the defense side, he's been exceedingly active with the International Bar Association's program in providing training for the special tribunal, both the judges and the prosecutors, and also in the defense attorneys in the Cambodian tribunal as well. So, Stuart, we're delighted to have you here. He's going to talk a bit about this relationship that came up earlier in the panel discussions this morning about genocide and crimes against humanity, and particularly from the perspective of the victims. So, Stuart, thank you.
Love is an ideal, and marriage is a reality. And it's important that we don't confuse the two. The Convention to Prevent and to Punish Genocide is an expression of a reality, is an expression of an ideal. The efforts of courts and tribunals to punish are the reality. And here we're talking about the realities of staging trials to punish those suspected of genocide. Now, of all those realities, to the person who is on trial, the reality is perhaps sharpest of all. To be successful, a marriage has rules. Those rules may differ between marriages. It's what makes some successful, no doubt, and some not. The punishment of genocide, so the second limb of the Convention's title, also has rules. We've given it rules. Those are the rules that lawyers describe as the rule of law. The rules themselves are embodied in a series of different ideals, recognised at an international level. Rules of legality, the fair trial process, expressed perhaps most comprehensively in the International Covenant on Civil and Political Rights, perhaps the single document that contains within it what we collectively express as the ideal of fair trial and legality. The Convention on Genocide doesn't contain within it, of course, any of the rules by which we are going to punish. It simply sets as an ideal that we shall. It gives two options, doesn't it? One, to punish nationally, or secondly, to punish internationally, at that time in a court unknown. Now, no doubt under national systems, the punishment will follow the rules within that national system. And as we know from Iraq, as we were hearing earlier today, there were efforts to try and adapt the national system to fit more closely with some of the expectations that were held internationally before the trials themselves were staged. At an international level, of course, the rules are not laid down in the Convention, and they are not laid down anywhere else as a set of rules that can be followed by the courts. And so the courts themselves have had to work through and untangle some of the issues. From a defence point of view, this might create some problems. Because although it's a burden for everybody, of course, to work in a situation where the rules are not settled, a fundamental principle, one that Mischa touched upon, would say that those issues which are unsettled should be resolved to the accused's favour. I wonder, if we look back on some of the decisions of the courts that we have seen, we can always say that has happened. One of the legal tangles that has had to be unravelled by courts is between genocide and crimes against humanity. And we know, of course, that jurisprudence has now laid down quite clear definitions developed to identify the various elements we've talked about throughout today. But that overlap and proximity which Bill Shabas started discussing this morning, but which has continued through a number of our panels during this afternoon, has to some extent, of course, been eroded. It's been eroded by the developments since 1948 that have seen the distinctions between genocide and crimes against humanity largely disappear. There have been judgments which have considered the multiple convictions of individuals for sets of circumstances which may be covered by either definition, genocide or crimes against humanity. At the ICTY, ICTR, there have been plenty of decisions which have considered that very issue, resolving that multiple convictions are permitted where an offence carries, or each form of the offence carries a materially distinct element. But the point that's come up consistently through today, which has not yet had a defence voice to it, is whether it matters from a defence point of view. We've heard, of course, whether it matters from an international point of view, and Joan Mendes identified a number of very persuasive arguments why it does matter on an international level, because if labelled genocide, by his experience, one gets a different reaction, whether it's down at the UN or elsewhere, if on a scale which he described in terms of the Holocaust in Rwanda, it can be said to be a genocide. From the international community's point of view, therefore, we have discussed this. We've discussed it also from the community's point of view in the last session with the prosecutors, about whether it matters to the communities themselves whether this thing is described as a genocide or crimes against humanity. It probably doesn't matter much from the media's point of view, because we know the media will call it war crimes, whatever. It might call it genocide if it can get that into the title. What we know is they'll never call it crimes against humanity. Who has ever seen a title in any publication which contains the phrase crimes against humanity? Presumably it's just not snappy enough. But from a defence point of view, there must be mustn't there, some consideration given to whether genocide or crimes against humanity matters. A lot of that may rest upon the very stigma that the expression carries. To be labelled a genocidaire must matter. It may not matter to your sentence, or so we might think, if we look to the international instruments, to the sentences that are prescribed there, because, as we know, the sentence for genocide and crimes against humanity is essentially the same. But one wonders whether that will be the case if, in the future, we see the continuation of the development of domestic systems taking over much of the prosecution. Because in a domestic setting, one can imagine more clearly that there may be a distinction made between genocide and crimes against humanity if this relative position of the two crimes is to be maintained. And of course, from Iraq, from the recent experience of this year, we can see just how that may matter. Because if the trend towards domestic prosecutions is going to continue, and if countries are to be encouraged to deal with their own prosecutions, we take the consequence of the systems that they employ. And systems like Iraq, which carry with them the death penalty, may include within them the possibility that the distinction between genocide and crimes against humanity may have a very real bearing upon the way the court acts. Because if we are going to grade this offence, genocide as against crimes against humanity, so the sentence may make some difference, in systems where there is the death penalty, it may make a very great difference how someone is convicted. This isn't, I would suggest, an experiment in stretching the definition of genocide. We've heard quite a lot during the other panels and the other sessions about the opportunities to develop, perhaps to prosecute at the edge of the envelope. I think that was Robert's expression, a way of putting it. But from a defence point of view, the suggestion that this is an opportunity to try and move the boundaries of our understanding of the offence has a very real bearing upon the individuals who face the court. In pursuing the ideal, which is the punishment of genocide, it's important, isn't it, to look to our other ideals, and amongst those, the ideals of legality and fair trial, and see that we don't compromise those ideals in pursuit of the realities of our trials.
Stuart, thank you very much. I'm now going to ask for Nick Stewart to continue this discussion. Nick, again, is, as with Stuart, is an English barrister. He's a QC. Again, a very distinguished barrister in England, but uniquely qualified for this panel because he defended Krajišnik, and he successfully obtained an acquittal for Mr. Krajišnik on all charges of genocide. Now, the fact is he did get 27 years for crimes against humanity. But nonetheless, quite successful. He's now defending Petkovic, the general from Croatia, in a new case in front of the ICTY. So, Nick, we're delighted to have you here. He's going to speak a bit about the accompanying jurisprudence that's come out of his experience in the Krajišnik case, which, again, for this panel is quite unique. Nick, thank you.
Well, thank you, Mark. Krajišnik, you can see the top line behind me is Serbs. On the left is an ex-Serb called Milosevic, and on the right is Mr. Krajišnik. Why, following Mark's comment, do I think of the old joke, that was a successful appeal, we got you off the drawing and the quartering? It is true, Mr. Krajišnik was convicted on everything else, which actually was pretty much all the things we've been talking about, extermination, persecution, and all that sort of thing. We talked about love and marriage a few minutes ago. Mr. Krajišnik and I were divorced at the end of his trial. He is appealing, so I've got to be a little bit circumspect what I say. I would anyway, because he was my client after all, and he is now appealing, and the prosecution are appealing. He's appealing all convictions. The prosecution are appealing sentence. They're not appealing the acquittal on the genocide charge, which is important. That gives me a little bit more freedom on that one, after all. The basic outline, and I'll have to take it that though not everybody probably knows all about Yugoslavia, in fact nobody knows all about Yugoslavia, I can't give a potted history of that, or that will use up all my time and more. But it was Bosnia we were talking about, and the Serbs in Bosnia, who included Krajišnik, at late 1991 and early 1992, it became pretty clear that they and the Muslim population in Bosnia, because Bosnia was a very mixed population compared with other republics in former Yugoslavia, they were increasingly, it was apparent they were not going to resolve their differences. War broke out at the end of March 1992 in Bosnia, and the Serbs, what they had in mind, and there isn't really any issue about this, they wanted to carve off a bit of Bosnia for themselves, and because Bosnia was described as a leopard skin, there were majority Serb areas, there were majority Muslim areas, there were majority Croat areas, but the Croats were a smaller number than the Muslims and the Serbs. But they were all tangled up all over the place, and you'd have a broadly majority Serb area, but there'd be pockets of Muslims and Croats, so it's all really complicated. The only way in practice that this could happen was by what did happen, which was by, if I say wholesale movements of population, I'm talking about movements of population which were not voluntary. It happened on all sides, but to Kokwe not being a defence, as far as Mr. Krajišnik was concerned, is what the Muslims did. The basic point is that he was very close to Karadzic. The judgment describes him and Karadzic as being the main figures in Bosnia. The prosecution allegation was always that he was number two, and based on the findings of the trial chamber, it's hard to dispute that he was there or thereabouts, and the leader of the republics, or the Bosnian Serb army, was Mladic. So those are the three big figures. Of course, it's Mr. Krajišnik's misfortune at the moment. He's the only one of the three to have actually got, not voluntarily, but got to The Hague and been convicted. The point about genocide, I'm not going to go into elaborate analysis, or any analysis really, of the law of genocide. You've got an intent on two levels. There's got to be an intent to commit the crimes on the ground, as we always call it, the murder being one example, or killing is described in the statute and in the convention. There are other ways of committing genocide. That's one intent. The accused has got to have the intent to have committed those crimes. He's going to have, in this particular case, it's going to have been from above, as it were, as one of the leaders. He's not actually going to be out, and nobody suggested Mr. Krajišnik was actually out killing people. But that doesn't mean he was taken very clearly to have had the necessary knowledge and intent from everything he knew about what was going on in relation to the crime on the ground. But the important level of intent, and this is where the charge was rejected, is the specific intent, the mens rea, to commit genocide, the genocidal intent. And the simple finding there was that even one sentence from page 391 of the pocket-sized judgment that you will slip into your pocket and go home with, and that's not even at the end, they're just building up suspense at that point. But even the more extreme statements of the accused, such as his speech at the Bosnian Serb Assembly session of 8th of January 1993, do not enable the chamber to conclude that his intent went further than the removal of Muslims and Croats from territories in Bosnia-Herzegovina. Now, the way in which they were removed, of course, led to conviction on the trial chamber's findings on all the other charges. Crimes against humanity, there were war crimes as well, there were detention camps, and so on. So, very serious charges. But the genocide charge, I don't know, I wasn't there, obviously, in the prosecution discussions, I can't read their minds. But it does seem, from what one picks up, what you can see from the case, it was politically driven in the sense that the prosecutor, particularly, I think, Mrs. Del Ponte, wanted a genocide charge, wanted a genocide conviction, of course, if it could be achieved. What's important, I think, here is Mr. Krajišnik's association with Karadzic would mean that when Karadzic turned up, if he turns up, he will be charged with some other things as well, but he will broadly be charged with all the things that Krajišnik was charged with. And the world probably does expect Karadzic to be charged with genocide, which goes back to some of the issues that were discussed in the prosecution session. Now, they'll get that with Karadzic in relation to Srebrenica, which Mr. Krajišnik was not charged with. Karadzic, as I understand and what I remember, he is. So that's been held to be genocide. I think that's questionable. We can't debate that this afternoon, and it's been held. So the prosecution, we know this as well, there's no secret, the prosecution didn't expect to succeed on genocide. Now, it doesn't follow that because you don't expect to succeed, you shouldn't charge. I may come back to that in a moment if I've got time. But they didn't expect to succeed on genocide, and nor did we expect them to succeed. As it happens, in the Krajišnik case, I don't really think that the addition of a charge of genocide can have significantly increased the length of the trial or the evidence that we had to look at. Because for practical purposes, although there had to be argument, of course, about the specific intent, the crime base and all the facts were pretty much the same facts as the prosecution was going to have to adduce and bring evidence on anyway in relation to all the other charges. A bit extra. What I do feel is that the genocide charge led the prosecution to be constantly reminding the trial chamber of some of the more purple passages from the speeches of Karadzic, with whom Krajišnik was associated. So we would get a lot of stuff being waved under the trial chamber's noses constantly, these extreme statements. I think we probably would have had a bit less of that if there hadn't been the genocide charge. But you're not talking about very much in terms of time or resources. But the sort of cases, there are other cases that Christine Chung refers to where it's quite clear that a genocide charge might significantly add to the length of the case, and then all the considerations that she mentioned come into play. Now, I agree with, but not going to reiterate it, a lot of what's been called the semantic point this afternoon. The crimes with which Mr. Krajišnik were charged has been convicted as things stand, are very serious crimes. But it would be naive to suppose that the top crime, the mother of crimes, if you like, the top crime of genocide, wouldn't have been marked with a heavier sentence. And I feel safe here because there isn't an appeal on genocide, so the question of him getting his sentence increased because of a conviction on genocide doesn't arise. If it did, then I would really not have been able to touch that topic at all. But he got 27 years. I'm not going to comment on that. That would be foolish and inappropriate. But if he had been convicted of genocide, then in this tribunal, I don't think it's realistic to suppose that the sentence would have been 27 years. It would have probably been, and I'm safe to speculate now, it could easily have been life imprisonment, it could easily have been 40 years or so. It certainly, I think, would have been 35 years. I think it's safe to speculate. It would have made a difference. And it is a different crime. I don't dispute that. I think we can see that, for example, in relation to Christine Chung's reference to deterrence by investigation, it's not going to make much difference to the deterrence, is it, whether you're being investigated for war crimes, crimes against humanity that are going to get you 25 or 30 years if you get to The Hague, or whether you're going to get 40 years. You're going to be pretty deterred anyway, aren't you? And other people, if they're going to be deterred at all, which unfortunately they often aren't, they're going to be sufficiently deterred by that prospect. So it probably doesn't make a difference there. And as I've indicated, the same broad point arises in relation to defending, apart from obvious technical issues. The question of specific intent. Obviously, you have to grapple with the specific charge of genocide where it's there. The broad approach is the same. I'm assuming that these cases are generally cases where the accused is a leader or a controller, though, of course, one killing on the ground can be genocide, but that's not normally what we're talking about. So the broad approach is the same. The defendant is they very rarely accept privately that they've done anything wrong. I mean, that's a fairly common feature of defendants before these tribunals. What you're going to try to do is just distance them from it. It's their knowledge of what was going on. They're normally not doing the actual killings themselves. It's their knowledge of what was going on in the ground that you're trying to pick away at. And generally speaking, if you haven't made progress by the end of the prosecution case, the chances are that your defence case isn't actually going to save you. And so I think my last comment, because I see already I've only got about 2 minutes, is that on this question of education, I found myself being a little bit sceptical about this outreach suggestion. See, the question in Krajišnik's case is whether the prosecution was better or worse off for having charged him and failed on genocide. Because the immediate reaction in Bosnia, for example, entirely polarized. Serbs, well, at least he was acquitted of genocide, he shouldn't have been convicted of anything else. And the Muslims saying, oh, it's a disgrace, it's a terrible disappointment, it's a gross injustice, he should have been convicted of genocide. I'm a little bit sceptical about the idea of this one-to-one explanation to victims of how somebody hasn't been charged with genocide. Most of the region would be involved in either being educated or doing the educating when you look at the number of people involved. And I just wonder, it's just my last comment really, I wonder whether with that comment the education really, it's not my speciality after all, this isn't my business up to a point, but whether the education is most effectively done at that level, because what I read and hear in the media all the time on this is very loose. What I hear from politicians is very loose. And what I wonder is whether charging genocide in circumstances where it seems, from what Robert Petit was saying, that sometimes it's the pressure from victims which is leading to a charge of genocide. I mean, perhaps I was misunderstanding, but if there isn't the case there to charge genocide, you shouldn't charge genocide, because the victims would expect it. You just shouldn't charge it. And I wonder whether that doesn't add to the confusion. If you do include genocide charges where they're not properly sustainable, then don't you just add to this confusion of the relative importance of these particular crimes? So shouldn't you just emphasize, if you don't charge genocide, that the crimes you have charged with are very serious crimes, which one have to accept they are.
Nick, thank you very much. The last panelist, Elise van Sliedregt, is a professor at the University of Amsterdam. She's known in the international community because she's written extensively in this particular area, particularly in an area that we've asked her to talk about, which is this emergence of the use of joint criminal enterprise, and of course the focus on command responsibility as well. So Elise, welcome.
Thank you very much. I feel a little bit out of place being the only academic on this panel, although I have done some work, some defense work. At the beginning of my career, I will basically give some reflections from an academic point of view, and indeed it will concern some of the conceptual problems that arise in genocide cases with regard to liability, especially of leaders who have committed genocide, who are very often far removed from the scene of the crimes, and who are held responsible for crimes committed physically by others. And then the first, I'll make 4 observations. And the first goes to the definition of the special intent, or the interpretation of special intent. We've discussed it elaborately already today, and it's very clear that it is a purpose-based approach, interpretation. What does that mean? Well, basically that a purpose has to be shown. It has to be shown that the defendant clearly was seeking the destruction of a particular group. Now, I was intrigued when the other panelists were asked if they could change something about the Genocide Convention or some of the statutes of the tribunals, what would they change? If they didn't say anything about the special intent interpretation, because to my mind, this purpose-based approach is not necessarily the only approach that comes from the travaux préparatoires of the Genocide Convention. And in fact, in academic circles, there has been a movement, or some have argued that the ICC should take a fresh approach and should take a knowledge-based approach, so making this special intent a lower, degree of intent, where genocide would comprise those acts that one knows lead to the destruction of a group, of whose foreseeable consequences the destruction of a group is also genocide. And maybe that wasn't mentioned by the panelists on the other panel, because actually in practice intent very often is inferred. It's inferred from the high number of atrocities committed against the protected group, widespread nature of crimes, the fact that victims were systematically selected, And one wonders whether this truly satisfies the purpose-based, this special intent. To my mind, it is sufficient to prove knowledge. So in practice, it may actually be that we do have a knowledge-based approach rather than a purpose-based approach. And that brings me to my second observation, is that with regard to accomplices, those aiding and abetting genocide, knowledge is sufficient. And there's been at the ICTR a real inconsistency with regard to that. That's because of the statute, and it's poorly drafted in that sense, because you've got the genocide definition, where complicity to commit genocide is one of the acts of genocide, and on the other hand, you've got the provision on criminal responsibility, aiding and abetting, with regard to all the statutory crimes, also thus genocide, and aiding and abetting generally only requires knowledge. So one who renders assistance to the commission of genocide, who knows of the intention behind the crime, can also be held responsible for aiding genocide. However, some ICTR trial chambers, to my mind surprisingly, have found that probably with regard to complicity to commit genocide, a full special intent is required. Now, then there were also trial chambers that said it the other way around, and it's been really, not exactly an example of clear rulings, and to this date it's still, I think, a very unclear body of law. Third point, command responsibility in genocide. How do we combine the two? I mean, command responsibility is mission liability. You are held responsible because you failed to intervene certain crimes being committed. And already early at the proceedings of the ICTR, Mirjam Damaska, in a very powerful article, said it's incoherent. You can't combine command responsibility, which is negligent omission liability, with a special intent crime like genocide. And at the ICTR, we have convictions combining the two, and I'm still not sure how that can actually be, how one can be convicted on the basis of command responsibility. So that's the third point. Last point is joint criminal enterprise. It was already mentioned. Thank God it's not been mentioned very often today. It's a very complicated doctrine. I'll stick to a few comments. Joint criminal enterprise is basically, as you probably know, participating in an enterprise where all those people that are part of that enterprise are held responsible jointly in an equal manner for a particular crime. And even when crimes have been committed that are not part of that plan but that are foreseeable consequences, natural foreseeable consequences, you can be held responsible for those crimes. And the big question is then, what if genocide, can that be a foreseeable consequence of a joint criminal enterprise? To my mind, when the joint criminal enterprise is a small criminal enterprise and you can align it in that sense to aiding and abetting and a derivative form of liability, yes, it's possible. It does make sense. But when we've got large enterprises, as we had with the Krajišnik case, where you've got leaders, those at leadership level and others physically committing the crime, huge criminal enterprises where those physically committing are anonymous perpetrators. With Mr. Krajišnik, he didn't know who committed those crimes. Can he then be held responsible under that doctrine? From a criminal law perspective, and the principle of culpability then springs to mind, I doubt that very much. When there's no physical or intellectual proximity amongst those participants, how can you then do that? How can you then convict for genocide? And again, the special intent is problematic. So these are a few of my comments. And why is this important? I mean, I heard earlier on the panel, I believe it was, that explaining to victims whether it was dolus eventualis or a special intent doesn't really matter. But I think it does matter to defendants because, their convictions based on rulings that sometimes have not been coherent. It matters to academics like myself when you try to make sense of genocide law. And I would argue that some of the genocide law is bad law. It really is inconsistent in parts, and it may be a result of the fact that the Genocide Convention is not a criminal law statute, and to operationalize it, you need, a good criminal law mind, and I would actually pose the proposition that some of the decisions that come out of the ICTR particularly have not really helped us in that respect. So I think that's where I'll leave it, and I'm very happy to answer questions on anything you'd like to ask.
Elise, thank you very much, and thank all the panelists for sticking to the time frame. And this allows us to have about 20, 25 minutes of questions from the audience. I'll have a series of questions, but I'll hold on mine and open this up to the audience first, and then see what we get to say. Robert?
Thank you. First, I want to clarify something. I never said you should charge someone for genocide for political reasons. I just said it's a reality that you have to deal with as a prosecutor to explain that. I'm curious. There's a couple of comments, actually, about the effect of a genocide charge and deterrence, or your clients never admitting that they did anything wrong, that sort of thing. I mean, does it matter to accused a difference between being charged with genocide and being charged with crimes against humanity? Does it really make a difference? Either in terms of deterrence or in terms of their brief that they give you, or their actions that they take?
Well, within the confines of what I could properly say, I can safely say Mr. Krajišnik expressed outrage that he'd been charged with anything at all and brought to The Hague at all. And so he, I will say a lot of very admirable things about Mr. Krajišnik. He is tough and he is persistent, as I think many of the negotiators that dealt with him found. He's certainly tough, persistent, and very consistent. He was, he didn't accept anything. So the question of whether he felt more or less outraged about genocide didn't really come up. Clearly he was given whatever advice reflects the reality of what's likely to happen if you're convicted of genocide as well as everything else.
Mischa?
Yes, well, actually, from a very practical point of view, there are two levels. One is the tougher the test, the better for your client. So if you would prosecute for a genocide, you make your life as a prosecutor a little bit difficult, and my life a little bit easier, little bit. And the other observation is, yes, of course, on the PR level, in terms of how the public is looking at your client, it is much different whether you prosecute him for genocide or any other crime. At the end of the day, it doesn't matter that much, really, because if there is a conviction for a crime against humanity, still the onerous effects of it are as large as if he would be prosecuted for genocide. But to start with, from a technical point of view, there is some difference indeed.
Well, the difference, I mean, you I suppose one could say from the point of view of defence counsel, one advantage of having your client charged with genocide in those circumstances, you're going to achieve at least one acquittal. But it doesn't really amount to a lot more than that, because it doesn't help you on the other charges anyway, because they're going to stand or fall. But it's quite plain that it's going to affect sentence. So that's the basic point. So of course it always makes a difference.
I think that it would affect sentence, as Nick says, that must make a difference, whether the individual expresses that and understands that. I think in a more abstract sense, his rights must be that he's convicted of the right thing. So whether he knows that and he can articulate that, I'm not sure that particularly matters, but in the sense that defence counsel protects his rights as they're understood, then it does matter that he's convicted of something that is consistent with the tests as they're understood by the law, even if they're not as understood by the individual himself.
Bill?
Thank you. Well, nobody's spoken about plea bargaining, but we have several examples at the Yugoslavia Tribunal of plea bargaining, a few at the Rwanda Tribunal, a few recent ones, and it strikes me that in every case, people cop a plea to crimes against humanity in return for getting the genocide charge dropped. Now, doesn't that suggest something about the relative gravity and about the interest of the accused and the defendant? Did anybody hear of someone offering to plead guilty to genocide if they drop the crimes against humanity charge?
No, but that's precisely because it doesn't help you. Because if you plead guilty to genocide, you get off the rest. You get the top level of sentence. So all that anybody's interested in plea bargaining is reducing the sentence. So and Plavsic, I mean, let's give a specific example with Mrs. Plavsic. The Iron Lady, but I mean, there's an Iron Lady in the UK. She's the Iron Lady Bosnian branch. So she was charged jointly with Krajišnik. So he's not the only one to have been brought to The Hague because she was in The Hague as well. But she only pleaded to persecution, which, by the way, is a crime. It was said, well, how do you explain to the victims, if you don't have the genocide charge that they've been killed or whatever because they're members of the particular group. Persecution covers that as it happens, just as extermination covers mass killings. That's why I'm saying that these other crimes do cover a great deal of the ground. But nevertheless, genocide is the big deal. Of course, you're absolutely right, Bill. I mean, nobody's going to plead guilty to genocide. And no prosecutor's going to offer a deal where they say, well, just do the genocide, we'll let you off the rest. I mean, okay, you didn't have a TV license. All right, okay, all right, so...
Others?
Well, I recognize these come up in front of different forums. To what extent are the prosecutors and defense counsel permitted to comment on the trial during the trial?
Mischa?
Mischa, you might want to give some background to before you answer this.
Actually, I wasn't a defense counsel when that happened to me, but it did happen to me, so I'm more or less an expert by experience. As an amicus in the Milosevic trial, I gave a comment. I thought it was on the safe side, but it turned out to be on the risky side, and actually that was one of the reasons why I left. Lesson to be learned is a clear one. Don't comment whatsoever. Now, there is a practical issue, and we have to keep that in mind. And perhaps we come back to that because it is an issue in the context of equality of arms. Because equality of arms is not only limited to what happens in the courtroom, but perhaps also maybe extended to what happens outside of the courtroom. Now, what is the issue? The issue is this. These tribunals, or these courts, as well as far as the courts are involved and the office of the prosecutor, do have people who only have as a job to inform the public. So let me put it in my words. They have PR officers. So they are able to communicate with the media and everyone else and explain their positions. They are well educated, trained people, professionals in that area of PR. We, defense lawyers, we are not trained to do so. We do not have an office of PR officers to communicate with the media and with everyone else. We are not trained to do so. So these people jump on you, they talk to you. And indeed, it may happen that if you do not keep your mouth shut, which is a lesson I learned at least, you're lost, because it may happen that you overstepped the line. But the pressure on you to give any kind of comment, or at least to react, to give some kind of factual information which is not any comment whatsoever, but only, yes, we had a hearing today, yes, there were witnesses, that kind of stupid kind of information. It's extremely difficult because there's a lot of pressure. The British colleagues have an easy task there, because according to their code of conduct, they are not allowed to communicate with the media whatsoever. So they have learned the lesson from very beginning: don't speak with the media, full stop. I'm from a jurisdiction where they do not have such a rule, so you're really on your own. You have to learn by experience where actually the line is. And that's what happened.
Yeah. Well, I should say actually, a couple of things actually. I've actually had quite a lot of media training, and I think how awful I would have been if I hadn't even had that. It's code of conduct. It's not quite right. I mean, our code of conduct does give us a little bit of freedom, though it does require you to use your common sense and judgment. But we try to do that as much as we can anyway. But I did actually. I used to give during the Krajišnik case, which went for 2.5 years, for heaven's sake. I did give factual briefings to journalists. After all, why shouldn't you, from the region, why shouldn't you just tell them the actual facts of what's happening in the case and increase the chances that they might actually get it right? And I did, I think, on one occasion, but in the same way, on one occasion, I did a very short clip interview for some radio or TV station in Bosnia, but again, it was purely factual, and there isn't a restriction on that. But you'd be very sparing. I mean, to answer the question, you'd be very sparing. You're not going to express judgments, tactics, anything like that. Just purely factual, if anything at all.
Mischa put a term out, equality of arms, and that's such a prominent issue, I think, in the international criminal trials. The idea of having some degree of parity between the prosecution and the prosecutor and the defense. But I'm curious, Mischa and Nick as well, then, if you look at the years that have passed from that first Tadic case, where I think equality of arms issues were quite severe and really, I think, had a real deterrent effect on your ability, I think, to defend, actually. Is it better now? Do you find the same issues now as you move up to the Krajišnik case, as you move up to current cases in front of trials? Has the international community been responsive on this issue of equality of arms?
Well, I don't know. When I hear the phrase equality of arms, I reach for my revolver. No, it's tremendous inequality, and actually, privately, the prosecutors will acknowledge that. It may have got better, it may have got worse. Mischa probably knows better the progress of
well,
that.
actually, there is some difference, but whatever the difference is, at the end of the day, what still is on the table is a large difference in resources, a large difference in know-how. I do remember when I arrived at the Rwanda tribunal, first thing I did was going to the registry, asking, can I have copies of the case law so far? No way. Hush, hush. We have to ask. And 1 month later, nothing was on the table yet. That has improved. I mean, the case law has been made public. It's now accessible. And that is an improvement. But still, not everything is accessible, because the Office of the Prosecutor has access to all the case law, even on procedural issues. The small issues on motions, not accessible for us at least. So there is a difference there. There is a difference in access to evidence. I mean, when we are abroad doing our discovery on location or any form of discovery to find out what we can have, we are individuals. We ask an official to hand over a document. Why on earth would he hand over any document to an individual? So there is a difference again in the way prosecution may have access to evidence, and we have all these kind of problems. There is a difference in access to the court. The prosecutor has a much easier access to the court than we have. There is a difference in, as I already indicated, public relations. And I can go on and go on and go on. It has improved, but we are not yet there. But on the other hand, let's be realistic. This is not a problem of international tribunals. It's a problem at home as well. It's everywhere. It's a part of life and a part of reality.
I think it's worse, actually. But and this is not meant as a flippant remark. It's quite serious. And if anybody doesn't know about the Rzeszów case but wants to follow it, the way to get equality of arms is to go on hunger strike. Really, that's it's a fairly shocking story, actually. If anybody that doesn't know about the Rzeszów case, many will, but if you really want to see something fairly horrendous in action, check that one out.
And of course, the whole issue of equality of arms came up with the Saddam trial, and that was always a big issue that the international community focused on, and the Iraqis as well. A huge issue on that, Stuart.
Yeah, what doesn't seem to have been learned each time one of these tribunals is set up is the lesson from the one before, which is that the defence needs some representation. And each time one of these structures is created, the drive and all the motivation and the effort and the report writing and the management capacity is all directed towards the court and the prosecution to get the thing going and established and moving. And the defence comes along somewhere behind. We've seen it in every single one of the tribunals, that the defence seems to be some kind of afterthought. Of course, in a sense, it is an afterthought in that it takes the second place, in that you need the court and you need the prosecution to have a defence. Unless if there's no court and no prosecution, you don't need a defence office. But it never seems to be built into the management.
But the whole point is...
From the beginning.
Well, now, if I can, I mean, now, and I agree with Stuart, I mean, it makes, as a prosecutor, it makes your job a whole lot easier to have a competent defense on the other side. And, you know, in East Timor was the bane of the prosecution, I think it was that we didn't. But now, at least in Sierra Leone, and to a certain extent, a lesser extent because of certain issues in Cambodia, there is now an idea that from the beginning there should be a defense support office. There should be a principal defender. There should be somebody who can stand in right away from the very beginning. And it makes your job a heck of a lot easier. And hopefully, you know, makes the final product that better. So I think there's a little bit of a learning on that aspect of it.
Would you say then, David, as well, that we should always, in future cases, even domestic cases, if we head back to Iraq, always have this type of defense office that would exist?
Absolutely. If it's not done right, the end product doesn't matter, does it? So if both sides are not up to the same challenge, up to the same capacity.
Then that is a lesson learned from Mischa, from the Tadic case, at least.
The Defence Office is very important because it has a voice on budget. And what happens is if there isn't a Defence Office, there isn't a focus for someone to speak about that issue, they never get any share of the budget, be it of cars or resources or office space and all the rest.
Yeah. I should say we did have a special problem in the Krajišnik case because without going to the complications of the legal aid system, as you might loosely call it, Mr. Krajišnik didn't pay, and this is on the record, I mean it's on the public record, Mr. Krajišnik didn't pay his assessed contribution, so actually his entire defence had to be run on about 70% of what's deemed to be the amount that you need, which is not excessively generous anyway. But, you know, well,
David?
he pays your money, he takes your choice, I suppose.
Well, we certainly do have an uneven track record dealing with the Defense Counsel. When Robin Vincent and I were going around meeting with colleagues in other tribunals, we realized that we were actually frankly horrified in Rwanda at the level of support that the Defense Counsel were getting. And I certainly supported Robin Vincent's move to create the concept of a principal defender and giving the Defense Counsel and the teams the same amount of support that we received. And over time, again, it was just a simple issue of getting resources to Sierra Leone to do that, but over time, within a year, they were occupying the same type of trailers and getting the same kind of support. The principal defender was not actually defending anybody. He was an administrator, administering and representing the 9 defense teams that were working to fairly represent the individuals. Because we have to consider, at the end of the day, it's fairness, and it's people who have been victimized have to feel that the process was fair, because they're going to have to live with the end results. And it's really exacerbated in the Balkans, where you could never convince them. But in Sierra Leone, where we're literally right in the middle of the crime scene, at the end of the day, they were going to have to live with the result. If they felt that the process was fair, they may not have liked the result, but they probably could live with the result. Now, I'm not saying we're right there, but it is critical that we have some type of support as teams.
Thank you. Last question, David Chair.
I'd like to ask Elies a question. We talked together several years ago, and I remember our conversations were on joint criminal enterprise. I found your second point very, very interesting, and I just want to clarify. With your academic hat on, would you prefer to see the crime of complicity in genocide as a knowledge-based crime, but with your defense counsel hat on, would you like to retain it as a special intent crime?
Nice choice.
What am I going to say? I'm torn. Of course, as if I would be defense counsel, I would argue special intent, yes. But to be absolutely honest, I would find that difficult because I look at complicity and I can live with, or I think from a criminal law point of view, and if you look at what complicity generally in criminal law systems all around the world, how that is constructed with, for example, premeditated murder, which is a similar type of construction as special intent of genocide, I think knowledge is sufficient. And from that background, one could say that it's supported in criminal or general principles that knowledge is sufficient for those who aid and abet genocidaire. I have to then add that to my mind would deserve a lower sentence, aiding and abetting on a knowledge-based interpretation of special intent. So that is a difference maybe, and that would make me happy also maybe from a defense point of view, that there is a lower sentence then, because knowledge-based is a lower criteria.
Well, the great thing about being counsel is you only have to argue. You don't have to believe it. I mean, that's the whole point. So you're safe.
Okay.
I mean, just go ahead.
Mischa, Elise, Nick, Stuart, thank you very much for being here.